now Carola Musetti from the Ministry of Health, Argentina. Thank you very much for the invitation. I know it's late, so we can start by saying that this is not a balanced agreement for developing countries. The provisions that were beneficial to us in theory are programmatic provisions that are not objective, and the commitments we made, all the countries in the TRIPS, those of us who signed the WTO agreement, are now forced to implement certain modifications in our legal framework. It was a great effort to understand what we did when we signed those agreements. Since much has been explained, I'm not going to repeat. Something that is important is that intellectual property rights regime are territorial. That is, each country should respect the international commitments but can develop its own intellectual property system. Therefore, we did what Tomás mentioned in panel 2, that is the guidelines for patentability. We believe they are in compliance with everything, and the cases that the state is fighting, we believe sentence will be in our favor because we do not discriminate. We believe these guidelines differentiated things. The patent is a legal and technical tool. It is a legal tool that ensures legal monopoly for 10 years granted by the state, but it has two crucial elements. One is knowledge. We believe that patents in their beginnings were not created to hinder access to knowledge, but currently the patent is a business itself. They do not come to help somebody. They say, I want the patent, and that's it. It doesn't matter whether I created something new, if I invented something new. Argentina really values technical and scientific advancement, but not in every case a monopoly should be acknowledged. Not in every case we should force society or the community to respect legal monopoly for 20 or 30 years, with the implications in every area of knowledge, especially in health, because there are access issues. Intellectual property systems should contribute to the development of technological innovation, to knowledge dissemination, and to social and economic development. That's the goal. That's the goal Argentina understands they have. And the agreements, because the agreements are one thing, are the other parameter to read the legs. Everybody should understand that the intellectual property system should favor invention. These agreements, these treaties, these commitments that are on the slide have been discussed along the day, so I think we should not go back to them. I will just give you a personal comment. When I started working in the Ministry of Health, the only standard in force was the interpretation of the Doha Declaration on Public Health. Today, I believe we are worse than then, because governments understood we have a problem and we haven't found a strategic approach to solve the conflict that public health faces in terms of intellectual property rights. We've negotiated for many months on public health, innovation, and intellectual rights, and this remains in a specific group of discussion. So any reasonings we may have on intellectual property will make us face two dilemmas: innovation versus technology transfer. We acknowledge that innovation under the terms of the agreement, but we were not operational. We did not explain how that technology transference could be understood by the states that were recognizing the right. That was a difficulty we have when we created the standard, and we have not yet found a way to solve it. Another dilemma is that intellectual property holders have got rights that somehow face the public domain. This intellectual property right goes beyond the knowledge border. And we have to acknowledge that we arrived there thanks to the public domain. Nobody discovered anything out of nothing. We always have some basis to reach some new place. So we have to expand patents in a way that it should become simpler to get knowledge from the public domain, because we are extracting from the community benefits the community already had before the property right is granted. So as a state, as a government, that is what we are doing when we are granting a patent. And what are we looking for? Because we have not been able to materialize this into a benefit for the community. Thomas showed some numbers. The patent system or the TRIPS after 20 years has not demonstrated more developments in the health field. So we are defending the investment that is a respectable investment made by companies, but states should know what they are doing when they are granting a patent. So we are trying, as far as international agreements allow us and domestic policies allow us, we are trying to bring everything that and patent everything that may be in the public domain. This situation is because access comes from low layers, and it's easier to push down something than to push up. We may skip this, but we have to outline that we have to go back to the logic sequence, that property is not the legal framework of TRIPS, but the capacities that these rights support. And if we analyze the current situation before a number of agreements, for instance, Argentina is negotiating and has been negotiating for several years with the European Union, and we have a second negotiation for an FTI with the European Union. From the standpoint of people working in health, we visualize this problem, we know this problem, but we cannot formulate it. There are resolutions, and probably because WHO is or has resolutions that are not binding to its members. So these two resolutions came before many FTAs that are in force. So in short, when we negotiate an FTA, what are we negotiating? Which are the parties? Two states, or a state and a region? Currently, we have these two processes, and we are negotiating trade issues. but intellectual property rights are considered a property. These intellectual property rights are also negotiated. So we have to think that when you start a negotiation to arrive to an FTA, health is not the area that is asked. We are part of the table, thanks God, and this is a positive thing of the most recent FTAs. Health area is usually consulted, but the agreement is not defined by the positions held by health people in the table of negotiations, where we take part in the negotiations, especially patents and products, pharmaceutical patents and products. We find problems. We are not the demanding bands in intellectual property issues.
And because of this, we are at a defensive stance. So we sit at the negotiations table with no requirements. And this is what we have been doing early on, and with many requirements, demands. So the negotiation process is unbalanced per se for the intellectual property people. So Mercosur, Argentina, when it negotiates on its own, doesn't have huge requirements vis-a-vis the European Union when talking about the intellectual property, but the European Union makes big demands in the areas of intellectual property, both vis-a-vis Mercosur and Argentina. So in order to achieve a position which is not a defensive one, because if you're at the defensive, I say, well, if you ask me for 100, I will have to give you at least 5 because I am here to negotiate. And when you are negotiating, well, you know that you have to give and take. So we tried to find an area where we could be receiving. So we defined some items. I'm going to skip them because they have already been mentioned. Basically, the free trade agreements want to expand the protection of the intellectual property rights. We only give them according to an agreement of TRIPS, new uses and expansion of the definition of patentability, expansion of the protection term through compensation because of delays. And we all know these in general terms at least. We ask for certain treaties to be signed, and usually those treaties are within the WIPO umbrella. They try to set up a limitation in the use of the flexibilities administrations may have, especially in case of compulsory licenses and parallel imports. And we have an additional weakness being UNASUR, and it's that many members of UNASUR have already signed free trade agreements. So we are in a position so that is when we want to develop a joint tool, we have different positions regarding what we are going to accept and what we're going to negotiate on. Of course, if you have a free trade agreement signed, you all know what the consequences are. We may have different opinions, those, and the impact may vary, but in general terms, we know these treaties or agreements are not positive for the healthcare area in most of the countries, but I would like to stress that they undermine the growth of knowledge in general. If we had to mention 2 elements, basic elements, through which technological development has been achieved, well, one is through free experimentation. That is, you take the information that is available you take the memory information that has been related to a patent. You take the memory, you may experiment with this, and you also use reverse engineering, though TRIPS does not deal with reverse engineering. And here next to me I have a representative of the domestic industry, which is the case of Argentina, has been able to develop a strong domestic pharmaceutical industry at a time where the patent law would only grant patents for the procedures and not for the products. So through reverse engineering, the Argentine pharmaceutical industry grew significantly. Private industry in Argentina. There's another area of concern, at least in Argentina, and I think this is present in most of the countries, and it is that an increasing number of judgments which are not fully in agreement or don't fully respect the right to health. And we also have some elements, or what we usually call undermining in some areas of patents, and this actually means there is a sub-use, limited use of the system itself. This is a model we would use when the negotiations with the European Union were taken up again. We did a simulation, but we haven't agreed on the wording yet, and the basic scenarios were also discussed. But I would like to stress that in any of the scenarios we proposed in that study or analysis, we talked about the impact through a given uncertain scenario, the impact that the protection of test data in exclusivity would have, or the extended patent because of delays in the registration, and both the impact on the economic arena and on the health arena because of higher costs was really high. Of course, if we sign an agreement of this kind, the competition will disappear in the market. This is just logical. If you grant something a monopoly, you are telling everybody else that they cannot use the same product or agent, and of course competition would disappear. Of course, anybody who is able to get a monopoly will make the most out of it, and prices will go up, and thus access to medication drops, and thus the states who want to develop a program which has a social impact will eventually must make higher investments in health or for purchasing medications, and this also affects the domestic industry. In the case of the countries in regions which do have a domestic pharmaceutical industry. Finally, when we talk about the free trade agreement, well, I think that we should use the regional arenas as a defensive element. Both at Mercosur and UNASUR, we have very similar goals. I don't think we won't be able to achieve some kind of agreement that will enable us to use it in a negotiation when, for example, on an individual basis, Argentina faces the European Union. It's not the same for Argentina to say I have a protocol on intellectual property signed with the Mercosur, which is a standard regulation, which I should amend to grant you something, any right of TRIPS Plus, than negotiating with them just using our negotiation, and where things would only be changed by a communication between the executive power and parliament. I think we should go back to TRIPS and we should ask member states to see how they have complied with Article 66. We did this in 2 cases. We asked in the free trade agreement that they would explain to us what competition defense practices they had and in what cases that right was abused, because it may be a property right, but it's not unlimited. All rights must be used in a proper way, and the abuse of the intellectual property rights has also taken place. We asked the European Union to show us some examples, and we also asked them to show us what incentives, according to Article 66, what that the signatory countries of TRIPS had to create incentives to foster and encourage technology transfer to less advanced countries so that these may set up technology foundation that was strong and feasible. Though we don't have information or reports that show how the technology systems of developing countries or least developed countries have been benefiting from this system, we don't have seen anything on the other side, that is the steps that have been taken by the advanced countries. We also asked for the analysis of evidence related to other free trade agreements. That is, any of us negotiating a free trade agreement might ask any of our partners for an impact analysis, an example about any clause that has already been signed. And I believe it will be very useful for those countries in the region that have already signed FTAs to cooperate with those who haven't done so yet, but which will be signing those agreements in the future. So we are calling on those other countries to share with us their experiences so that we may eventually have an agreement which is more positive vis-à-vis our interests. Thank you very much.